A couple of things. First, I would like to recognize that Representative John Nelson's with us in the back of the audience, and I suspect he's probably here about one of the things we're going to talk about under the City Manager's report. Lastly, Vice Mayor, members of the Council, we'd like to take a few minutes and talk about a matter that's on the November 7th ballot. It's one of the many propositions. It was an initiative. It's called Proposition 207, Private Property Rights Protection Act. The Council has directed the staff to analyze this and to try to figure out how it would affect the City of Peoria. We've spent quite a bit of time on this, and we would like to report back to you some of our conclusions and findings. I'd like to make a couple of overall comments from my perspective as a city manager who's going to be charged by you with the job of implementing this if and when it passes. Then would also like to have a report from Mr. Schell and then Mr. Kemp at the end. I guess first and foremost, the thing that I would say about Prop 207, one of the most disturbing things to me is that I think it misrepresents what it really is. The pitch on this is asking voters to adopt something that is purportedly to control government abuse of the use of eminent domain. And of course, the use of eminent domain is use of condemnation to take private property for public purposes. The problem of this is that Arizona already has some of the strongest laws in the nation to control government in the use of eminent domain and to protect the private property owner. The legislature has done a good job in providing protections in this area. The problem is the small print on this is not talked about much when people are asked to support it, and that's the area that we call regulatory takings. It's my opinion that this has the effect, would have the effect of dismantling most of our land use regulation here in the City of Peoria. I'm going to give you 30 seconds on this. The city attorney is the expert. Generally, it says that if the council takes any land use action where some party believes it has diminished the value of their property, they have a legal right supported by law to a claim, and if that's found to be valid, then the city has to pay them in cash. And this is not something we do an insurance claim for. There is no insurance for this. The city would have to basically pay that claim. And there's no negotiation. One of the interesting things about a couple of the items that you acted on this evening is there was a negotiation process between the developer and the city and the neighbors. And you got a better product, a better project out of that. My understanding is that's not going to take place. If someone feels aggrieved, they file a claim, they take it to court, and off we go. The man behind this initiative is a gentleman named Howard Rich. He is a New York resident. He's wealthy. He's a millionaire. He is a libertarian, and he has contributed money in at least 12 states that we know of to these kinds of causes. In Arizona, Mr. Rich's money, well, it paid for virtually all of the campaign, including paid signature gatherers. This was not a grassroots movement. This was paid signature gatherers, and I am told that they were paid up to $10 per signature to get signatures on this. And I've talked to some folks who have talked to signature gatherers on this, and the pitch went something like, do you believe that if government takes your private property that you would be entitled to be paid for that? Well, sure. Who wouldn't say yes to this? Not much discussion about regulatory takings, and that, of course, is the rub. This same proposal, the Howard Rich Property Rights Program, was taken to Oregon in 2004. It's the only place in the country where this has happened. That's the model for Arizona. In Oregon, in 2004, they called it Measure 37. Now, it's worth noting that Oregon has been known to be a model of good planning, good land use regulation, and frankly, it was the model for many of the growth management laws in the country, including the state of Washington, Florida, and so forth. So in 2004, same pitch, same kind of law and so forth was enacted in Oregon. Well, as Dr. Phil says, how's that working for you? Well, if you ask somebody in Oregon, Measure 37 has basically dismantled land use regulation in Oregon. To date, there have been over 3,000 claims against government for diminished value in Oregon, over 3,000 since 2004, with an estimated worth of $5.6 billion. Hasn't been paid. There is no money to pay it. They don't know what to do. Government is basically frozen in this regard. I am told that lawyers advertise in Oregon with a pitch that says, let us help prepare your Measure 37 claims. So it's become a cottage industry for lawyers. And guess who one of the biggest filers of claims in Oregon is? Billboard companies. In other words, some government agency had the temerity to do something that would reduce the number of billboards or the exposure of billboards, filed a claim, you pay. This Howard Rich funded measure in Oregon, again, was directed and talked about abuse of eminent domain. The payoff was the regulatory takings, over 3,000 claims. Local government has essentially stopped regulating in Oregon. My understanding is what's happening is local government agencies are just not saying no. They're basically letting anything that stands go through. Their approvals, their regulations have been frozen because they're not going to do anything that looks like a change. Someone claims a diminished value, and then they pay. And if we do this in Oregon, and the same thing that took place in Oregon, it would be just Arizona and Oregon, and then we would join Oregon as the poster children for lousy planning in the United States. The public doesn't understand this. I think if you took the average person who signed one of these petitions or is going to vote and asked them for their understanding of regulatory taking, they don't understand. It's very complicated. Frankly, it shouldn't even be on the ballot. The problem with this is the public is not going to understand until after it's implemented. And the way it's going to happen is things are going to start happening. Developments are going to get approved. Applications are going to go through. And things are going to start to appear and happen in the community. And the public's going to start asking questions. Why didn't the city do something about this? Why didn't the city stop that? Why didn't you do something? And then the answer is going to be, our hands were tied. Prop 207. The big lie of Prop 207 is that it equates land use regulation with confiscation. It says if you regulate, you try to provide good planning, you try to regulate land use, that's confiscation. That's a lie, it's not true, and that's the conceptual flaw with this. If this passes, we are going to change the staff reports that come to you. We're going to change the format, and we're going to add a new category. And it's going to say something like Prop 207 liability analysis. Every report that comes to you that's going to have some kind of land use action, we're going to do an analysis and say whether or not this will expose the city to some unfunded liability due to this Prop 207. And if it does, I know what's going to happen. We are going to be recommending to you either to say no or take no action, because we don't have funding to pay claims. And if this becomes statute, that's what's going to happen. And that's how it's going to start. I'd like to call on Mr. Schell to give a short report.
Thank you, Vice Mayor, Council. For the record, my name is John Schell. I'm your Intergovernmental Affairs Director for Peoria. Terry has made my job easy. He's just basically said a number of the things that I was going to say, so I'll try to stick to some of the differences. Where did this come from? You mentioned a little bit about this. What really got this whole thing started and created the interest for this nationally was the case in New London, Kelo versus New London, where private property in Connecticut was taken, eminent domain authority was asserted by New London, and then it was conveyed to a developer for economic development use. We have to take a look at how this could potentially impact us as a city, and the first thing is, could this happen here? And Steve will elaborate on this further, but as Terry said, this is Arizona is one of the, if not the most strong private property rights states in the nation. We do have the strongest laws and regulations in the books that relate to eminent domain and regulatory takings. And Steve will elaborate on a few of the cases. And with your indulgence, Vice Mayor, I was going to ask Steve Kemp to make reference to the three cases that are mentioned in the declarations and findings in Prop 207. The first example that's always used by when you look at the billboards and you look at the print materials and you look at the commercials, the reason for why this is the proponents say this is needed in Arizona is because of what happened in Connecticut, and being the Kelo case. And so once you realize that that can't happen here, that the laws have reaffirmed the fact that we cannot take, local government authorities cannot use their eminent domain authority to convey property for economic development in Arizona. The second thing that's used after that to explain why it's needed here are some other cases that happen locally. And I'll come back to the funding of this in just a second, but if Steve could mention what happened in those three cases that are mentioned in 207, that would be useful.
Mayor, Council, basically, if you look at Proposition 207, the proponents argue that Arizona courts have been abusive to property owners in terms of protecting their rights against eminent domain, and frankly, nothing is further from the truth. You take the first case that's cited, it's a case out of the city of Mesa called Bailey's Brake Shop, and it involved the city of Mesa purporting to condemn Bailey's Brake Shop so that a hardware store could be constructed. The case went to the Arizona Court of Appeals, which ruled that Mesa could not condemn the property for economic development. So Mr. Bailey's Brake Shop is alive and well and working as we speak. The second case involved condemning a house in the city of Tempe, again for economic development, and the courts again ruled that you could not do that. The third case involved condemning a parcel in Tempe, which was a federal Superfund site, meaning that it was environmentally contaminated. Tempe was proposing to condemn the site so that a private developer would actually correct the site, expend all the money necessary to correct the site so that the federal taxpayers would not have to. And again, the property owners who owned the polluted property argued, well, you can't condemn it for economic development. The Court of Appeals agreed. Every single property owner, every single one, negotiated with the city of Tempe and reached a mutually acceptable agreement with the city of Tempe to purchase their property. Incidentally, I think it bears noting that as part of condemnation, not only does the property owner generally negotiate with the city, but they receive a significant federal tax break, and that all proceeds may be reinvested for 3 years without payment of any capital gains. And so the property owners in each one of these cases negotiated. They used an example of Chandler condemning a Jack in the Box. Again, Jack in the Box Corporation negotiated with the city of Chandler, reached a mutually acceptable agreement, and no condemnation took place. Arizona law, redevelopment law, has been amended to make condemnation for purposes of redevelopment in terms of transferring it to another party very, very difficult. In fact, many redevelopment districts don't even permit condemnation. It's not something that has to be permitted within the confines of the redevelopment law. And so, as has been said, Arizona is a very, very pro-property rights state, and the eminent domain types of abuses that are used as justification. The other side of the story is in each case, the courts provided a remedy, and the people received that remedy.
Thank you. And then, secondly, once you get past, staff, we were being asked to look at what would we have to do in terms of implementation if this were to pass. And in the absence of being able to find a compelling reason why this is even needed in Arizona, we tried to take a look around the country to see if there were any examples of where this has been implemented, to see how it's working and what the situation is. The only example that is available right now is the one that's in Oregon that Terry Ellis had just mentioned. And it turns out that it's being promoted by the same interests that are promoting and funding Proposition 207. If you strip away all the arguments for and against Measure 37 and you just look at what were the effects of that, because the same arguments were being used to promote that there as are being used to promote this here. If you take all that away and just say, what was the net effect? The effect has not been very encouraging. As Terry mentioned, there's $5 billion, and that's with a B, in claims against governments there, and it's basically brought land use planning to a halt. Okay, where did it come from? As Terry had mentioned, Howard Rich is the funding source. When you look at this and how it was put together, he has formed a couple of organizations through which to fund this initiative here in Arizona. Actually, as I look at this now, the chart's a little difficult to read, but I'll draw your attention to the very top box for the first organization. Americans for Limited Government has been the recipient of the funding for not only regulatory takings initiatives in various states, but also a taxpayer Bill of Rights, various versions of that in other states as well. But I'll draw your attention to the two that affect Arizona. Americans for Limited Government receives its funding from Howard Rich. Then the next one down, about 3 over from the left, says Fund for Democracy. Those two organizations are the ones that are cited at the Secretary of State's website for the organizations that are funding and that have funded this initiative. Up until recently, all of the money that got this to the ballot was from these two organizations. This is taken off of the Secretary of State's website. You can see that dating back to virtually the beginning of the year, all the fundings come from Americans for Limited Government. Total contributions $1.1 million. Fund for Democracy, as of this more recent reporting period, has contributed $25,000, bringing in a total of $1.142 million. So there's been some serious money put into this, and as Terry has mentioned, the paid signature gatherers were used to help put this on the ballot, and Arizona does happen to be one of the states that it's easier to get things on the ballot here probably than it is in other states, and this is an example of that. At this point, I will, unless you have any questions on this portion of it, Vice Mayor, I'd like to turn it over to Steve Kemp so he can go through the remainder of the slides and explain some of the specific ramifications of this.
Thank you, John.
Thank you, John. Let's talk about Prop 207 and what's its impacts, first on eminent domain. And as Terry alluded to, really eminent domain isn't the issue, but it does make some small changes to Arizona law on eminent domain. And as you can see here, it adds a statute that specifically states economic development is not a public use for which property may be condemned. Also, condemnation in a redevelopment area must be evaluated on a parcel-by-parcel basis, meaning that you would have to look at every single house and make a decision as to condemnation. One of the perhaps major changes is, right now the rule in condemnation is that when your property is condemned, particularly if it's a residence, that you are paid the fair market value of your property. And that is basically based on what appraisers show as the price that your property would bring on the market. This is going to modify that and say you're going to be paid the price to acquire a comparable dwelling. If your house is appraised value of $200,000 and it's a 2,000 square foot house, but the only house in your jurisdiction that's available costs $400,000, then the price that you're going to be paid is not what your house is worth, but what it costs to buy a comparable dwelling. And then the property owner will be entitled to attorney's fees on condemnations in redevelopment areas if the city's offer is not as great as the value determined in court by an appraisal. Now, the facts are, as I mentioned earlier, that the Arizona courts have already held that use of eminent domain to acquire property for transfer to another private party is not a public use. And, for example, redevelopment areas generally created by cities may provide that eminent domain will not be used. And a great example of that is the Central Peoria Revitalization District, our redevelopment district for Central Peoria. In the resolution that Council adopted, Council specifically said we would not use the power of eminent domain. And that is a very common thing that is done. More importantly, as a lawyer who's been trying eminent domain cases for longer than I'd like to think, I've been in public practice representing government agencies now for almost 22 years, and I've done eminent domain cases in this county as well as Pinell County. I've only been familiar in both places with one eminent domain case that has ever gone to trial. In every single other case, the property owner and the condemning authority has negotiated and reached an agreed upon value. I recently went to a seminar of condemning lawyers, basically those who represent property owners and those who represented governments. And these were basically the 50 lawyers in the state of Arizona on both sides who do this. And it's a very small group. Of all those lawyers, there were only 4 who had had a condemnation trial in the last 3 years. That's how rare trials actually are. Virtually all of these cases. The trial is an exception. They are settled by negotiation. So let's talk about regulatory takings and what's the impacts. First, I recognize long legal discussions can be really boring, so we don't want to do that, but we'll just talk a little bit about what current law is and try to put this in very straightforward terms. The U.S. Supreme Court has had a number of takings cases, and if anyone wants to discuss this, stop by and we can spend an afternoon talking about takings laws enunciated by the Supreme Court. But basically, you can crystallize it into 4 points. First, a taking has to involve loss of the economic use of the whole property. It's not just, well, you've diminished a piece of my property. I've lost the entire piece of property. Secondly, the property owner has to go through the governmental process. You have to go all the way through, you have to get a ruling from the government so that there's a record for a court to consider on what happened. Because a court doesn't want to act as a super zoning board, they want to have the record from the local government. Third, there is no taking if the burden caused by development of the property is roughly proportional. And that's actually a term the Supreme Court came up with the requirements imposed by government. In essence, if the burden over here is equal to the benefit caused by development over here, there's no taking. And finally, the courts will look, in terms of establishing value, at the reasonable economic expectations of the property owner, looking into things like zoning, regulations, and other types of constraints that, in essence, the mere fact that I may say, well, gee, I have a piece of property and I want to use it for single-family residential, and it's adjacent to an industrial plant, realistically, it doesn't have an economic value as single-family residential. And the mere fact that I may say that that's what I want to use it for, right now, the courts would not look at takings in that fashion. And that's because that's not what the reasonable economic value would be. So how does Proposition 207, if it was to pass, change the law right now? First, we no longer will look at the property as a whole. What Proposition 207 says is, if it reduces the value in any portion of the property caused by government regulation, I'm entitled to compensation, even if the rest of the property is usable for development. For example, if the city council says there's a 40-acre parcel and we think because of the foothills and the natural constraints, it needs some extra open space. Right now, we would say, well, we can do density transfers, we can make adjustments for that open space. Under Prop 207, a property owner says, no, you're reducing the value of my property because I'm having to give up more open space and therefore I want compensation. Secondly, there's no requirement that the property owner go through the governmental process. I can just go out and file my claim. So consequently, there's really no way of knowing what would the city council do. There's no reason for negotiation. As occurred tonight, you had zoning cases that the zoning applicants negotiated with the neighborhood and worked out a mutually agreeable solution. Under Prop 207, there's no reason to do that. Just file your claim. And there's no measurement of proportionality. The fact is, actions happen every day by government. Government may change the rules on certain types of accounts and remove a tax deduction. Does that mean that you suddenly get a right for compensation because government changed the tax law? No. Government acts in a number of ways, and the courts have never required compensation. And here, it doesn't even look at whether that development might result in major cost to the citizens. And finally, value isn't looked at the investment-backed expectations of a property owner. It's looked at the property owner bringing in his appraiser and saying, well, the most likely price I could get is X because I know I could use it for single-family home. It's flatlands. It is easy to develop, and it's in a prime area, and therefore that's what the value should be established on, even though it may be next door to a military base.
Ms. Dennis?
Steve, can I just ask a quick question? Going back to the area, for example, our hillside ordinances, things in our master plans of trails, things that we look at added value to development, would all these then come under question in reference to 207 then?
Yes, because what happens is each time we have these various ordinances, each time we act in a zoning case and it comes before you, you make new law for that piece of property. You enact a zoning ordinance, you impose these requirements. And then when that applicant comes through, we will again say, well, you now have to comply with this requirement. Even though the law may be in place, there will be subsequent actions that you would take after Prop 207 that would invoke a right to compensation.
Thank you.
So let's just sort of look at some types of actions that might be subject to compensation should Prop 207 pass. For example, the city might enact regulations, and it's very common, in fact we have, that limit noise, dust, sound, and hours of sand and gravel operations. If Proposition 207 is in place, that property owner is going to argue, I'm entitled to compensation for that. So what are the other impacts? Well, there is a significant impact on Arizona military facilities. And it has been said by some of the proponents, well, we really don't need to worry about military facilities because this doesn't apply to any law currently in place. There's one small problem with that reasoning, which is the state law on military facilities basically gives us a list of suggested uses around military bases. It doesn't impose those uses. It leaves those uses up to local governments each time a zoning case comes before a local government to impose those uses, or each time there's a general plan amendment. So should Prop 207 pass, every zoning case after that where we impose these uses could result in a diminution in value claim. So what are the types of claims that might lead to compensation? For example, should we choose to include additional areas inside noise and safety contours that might result in limiting development inside those areas to commercial uses? Right now, the guidelines around Luke, they don't prohibit development. They just say certain areas, because of noise and safety issues, should be limited to commercial development and not residential. And this change could invoke a right to compensation. Or, for example, if we add additional areas to territory within the vicinity of a military airport, which basically requires additional disclosure to subsequent buyers. Again, a claim for compensation. My property might not be as desirable for single-family homes if I have to tell people that jets are flying over it. Or if we establish new noise and safety contours for new missions, such as the Joint Strike Fighter. The fact is, at Luke, for example, which is an F-16 base, the F-16 is reaching the end of its useful life. There will be a replacement for that aircraft, and most likely, as it could be expected, it will be more powerful. It will need additional noise and safety contours over the existing contours for the F-16. Those new noise and safety contours under Prop 207 create a right for compensation. And then finally, what likely will happen is the cities, towns, and counties will waive the regulations. What happens? You now have homes and other types of incompatible uses against the military base. And what does that do? Well, we see the example of that with Williams Air Force Base, which was located over in Mesa. As you get more of those types of uses, the military can't complete its mission at that facility. So we do have an example we can look at. We can look at the Oregon experience. And in Oregon, the voters in 2004 approved Measure 37. And Measure 37, it does have some differences from Arizona, but it requires payment for the lost value of real property due to land use regulations enacted after the acquisition of the property by the current owner. And that's the short explanation of Measure 37. So what have been the impacts? First, there's been over $5 billion in land use claims filed in this 2-year period. None have been paid. Not a dime. In every single case where the case has gone to court, the state or local government has waived the regulation and allowed the development to proceed. There is no money to pay these. And just like in Arizona, these claims are not insured in Oregon. There's no insurance. The money comes out of the same pot of local government revenues that police, fire, parks, and your other governmental services come out of. So because any new regulation that results in a diminution of value creates a right to compensation, how have local governments acted? They've simply said, fine, we will just freeze our regulations in place as of the date of Measure 37. Even though we could make changes that might really improve the quality of development and make a better community for our residents, because we're going to get hit for a claim of compensation over here, we will just put everything in a deep freeze. And that is what has happened. What results? Increased conflicts and litigation. And as you will see in the next 3 slides, huge numbers of claims have been filed against local governments. This first slide is the area where you see Multnomah. Multnomah County is the county that makes up metropolitan Portland. It's on the north end of the state of Oregon, and basically metropolitan Portland sits within Multnomah County. All of those yellow dots are claims under Proposition 37 for new subdivisions of at least 4 lots or more. And the bigger the yellow dot, the larger the number of claims in that area. So the big yellow dots could be as many as somewhere between 50 and 230 claims, the smaller, much smaller number of claims. But that's just the number of claims by property owners seeking to build new subdivisions. This map, again, you see Multnomah County. The big green dots, these are areas that are either forest or agricultural land where property owners have filed claims saying, I want to build residential in these forest or agricultural lands because you've diminished my value. And again, the bigger the dot, the more the number of claims, or the more the number of acres that are involved. And finally, this map with the red dots shows any area where there has been a Measure 37 claim around the Portland metropolitan area. And basically, you're looking at the 5 counties that surround a metropolitan area. And this has been replicated throughout the entire state of Oregon. Here, you're just seeing the Portland metropolitan area, not the entire state. But this whole issue has been replicated throughout the state. And these are just the Measure 37 claims in that metropolitan area. So what really has been the Oregon experience? 1, waivers are granted for conflicting uses. For example, the city of Ashland, Oregon, an applicant wanted a sand and gravel pit next to a residential area. Files a Measure 37 claim, the city waives its regulation. In the areas outside Multnomah County, you have areas that are forest areas, areas that, much like in Arizona, you have to be very concerned about residential development because it increases the risk of forest fires. Again, residential development now is permitted. Scarce city revenues are used to have to hire staff to deal with this. Many, many Oregon cities hire just planners to analyze their land use applications for Measure 37 issues. They hire lawyers just to analyze their applications for Measure 37 issues. Again, where does that money come from to hire that staff? Out of the same pot of money that the city is using to provide day-to-day essential services. Perhaps one of the real big problems with Measure 37 has been it really removes predictability from land use decisions. We have a process. Both developers, neighborhoods, city staff, the community knows what the rules are. They know that there's going to be negotiation, there's going to be public hearings, you're going to come before the local governing body, and that governing body is going to make decisions based on taking all of this input into account. Here, you have a disgruntled person, I went off to the courthouse. I don't have to go through the local government negotiation process. And you end up with increased conflicts between property owners who make a claim and adjacent property owners who are impacted by that waiver of city regulations. So how would Proposition 207 affect us in Peoria? How does it affect the ordinary citizen when they say, well, why should I be concerned with this? How does it affect me? One, cities are not going to adopt new regulations to provide for open space, buffers, landscape requirements, or other types of regulations that improve our quality of life. Because every time you do that, there's going to be a flood of diminution of value claims. So the answer is, if you look at Oregon, we're going to freeze our process in place just like it is right now. I've heard some of the proponents say, well, cities have plenty of money. This paying these won't be an issue. First, these claims are not covered by the city's insurance. There is no money to pay for these claims unless you take it right from your general fund. Those same dollars that you use to pay for police and fire and parks and other services. That's where the money comes from to pay these claims. Lots of lawsuits. I can tell you as a lawyer, lawsuits are really not a very effective way of resolving disputes. Very expensive, very time-consuming, very intense, but not really very effective. Most disputes are far better resolved through negotiation and mediation and having the parties lay their issues out on the table and then coming to a mutually agreeable solution. This doesn't encourage any of that. Instead, it encourages going to court because I don't have to file an application. I don't have to work through the process. I can go right to court, and if I even win on one issue, I can ask the judge for my attorney's fees, and I may get them. So there is no incentive to work through the process. Almost all zoning cases are filed by developers. I think many times people in the public don't realize it. It's not the city who files zoning cases. It's people who want to use that property and develop it. Each of those cases may result in a Proposition 207 claim. So the city's solution may be to choose not to zone, and that results in lost jobs, lost sales taxes, and lost businesses in providing services to our community. We look at Oregon's experience. In Oregon, they have billions. We could well have millions, if not billions, of dollars in claims. None of them are going to be paid. This city doesn't have the money to pay millions of dollars of claims from its general fund without taking those monies from other services. So what's the solution? The same solution as occurs in Oregon. You waive the regulation. And important Arizona economic resources, such as our military facilities, are put at risk because development is now allowed to occur that interferes with their missions. This map here shows you Maricopa County, and this is actually a Maricopa County projection in 2010. The gray lines that you see show each city's general planning area. The red is the most intensive development, and then as the colors get lighter in terms of the yellows and ultimately the blues, less intensive development. You look at most of these cities. You take the city to the far left-hand side of the map, which is Buckeye, or you take Peoria, which you can see. Each of these cities has huge amounts of vacant land. Land that really hasn't developed. Land that will be developed post Proposition 207. And then you think of those maps that you saw of Multnomah County, and you see those claims. What can we expect in Arizona? Very much the same thing. In all of these undeveloped areas, property owners saying, okay, I don't want this regulation to apply to my property. I think it diminishes my value. I want compensation. And you just need to look at this map and you can see that, for example, in Peoria, we have a large area in our planning area that suddenly now could become a source of claims under Prop 207. And so with that, I'd be pleased to answer any questions that the council may have. I would note, separate from this, the mayor has requested a city attorney's office opinion on how we should comply with this, and that will be forthcoming in terms of the strategy should this pass and steps that the city will be using to comply with that. And with that, I'd be pleased to answer any questions that the council may have.
I don't believe you have any questions, Mr. Kemp.
Thank you.
Thank you. That was a very concise and very excellent presentation. Mr. Ellis, do you have more? Okay, we'll move on to reports from the City Council.